Attorney-client relations. Who gets to decide what the attorney does for the client? The rules of professional conduct provide certain parameters for the nature of the attorney-client relationship. There are certain things that are required. There are other things that are forbidden. And in the middle, there are various choices that the individual attorney and client can decide between themselves. First, I would like to turn to Rule 1.2, which addresses the scope of representation and the allocation of authority between client and lawyer. It is the client's right to decide the objectives of the representation. It is generally the lawyer's prerogative to determine the means of pursuing the client's objectives. The attorney may take action that is impliedly authorized to achieve the client's objectives. The client's rights include getting to decide whether to settle a case and for how much. In criminal cases, the client's rights expressly include deciding how to plead, whether to waive a jury trial, and whether to take the stand. The attorney is generally entitled to decide the means of carrying out the representation. For example, whether to conduct discovery through interrogatories or by depositions, or what motions to file. The attorney is required to consult with the client regarding the means of the representation and should generally defer to the client on topics of particular concern to the client. For example, whether to require his mother to testify or whether to pursue certain means that will be expensive to the client. Similarly, the lawyer is required to consult with the criminal defendant about the plea to be entered, about a jury trial, and about the client taking the stand before the client makes those decisions. Indeed, Rule 1.2 regarding the client's decision-making rights and the attorney's obligation to consult with the client must be read together with Rule 1.4 and Rule 2.1 regarding the lawyer's obligations to adequately advise the client. Rule 1.4b requires the lawyer to explain the matter to the extent reasonably necessary to permit the client to make informed decisions. Rule 2.1 requires the lawyer to exercise independent, professional judgment and render candid advice. Rule 1.2 also provides permission for the client and the attorney to agree to certain structures in their relationship. The attorney may agree to provide full service on a matter, to handle all aspects of a matter completely. This is still typical. Or, as appropriate, they may agree to limited scope legal services. For example, the lawyer may agree simply to advise the client, but not to undertake any action such as drafting documents. Or, the attorney may agree to draft the necessary documents for the client, but not to fully represent the client in litigation or negotiation. Whenever the attorney and client agree to limited scope representation, the agreement must be reasonable. For example, they could not agree that the lawyer will just be a scrivener. It would not be competent to draft court papers helping the client sue someone without first interviewing the client, at a minimum, to ascertain whether the client had a colorable claim. Note that the client must give informed consent for any limitation to the representation. Informed consent is defined in the terminology Rule 1.0 as the agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information and explained about the material risks of and reasonably available alternatives to the proposed course of conduct. Rule 1.2 also establishes certain things that an attorney cannot do for a client. Rule 1.2d provides that the attorney cannot knowingly help the client commit a crime or fraud. The attorney can counsel the client about his proposed course of action, for example, pointing out that a certain act is a crime, but the attorney may not tell the client how to make the crime look innocent or the best way to avoid getting caught in the commission of a crime. The rules make it clear that the attorney must sometimes tell the client that she cannot help the client with a particular project because it involves a crime or fraud. If the attorney begins work for the client, believing the project to be an appropriate one, and later discovers that she is assisting the client's crime or fraud, the lawyer must withdraw. If the lawyer continues assisting the client after he discovers the illegal nature of the undertaking, the lawyer himself may be guilty of criminal or fraudulent activity. Many of the lawyers who get into the biggest problems and end up being disbarred or going to prison are lawyers who have gotten sucked into the client's criminal enterprise, sometimes just helping to cover up the crime after it was committed. Think Watergate. The client is entitled to make informed decisions. As mentioned earlier, therefore, the attorney must explain the issue to the client sufficiently well for the client to be able to make an informed decision. This brings us to focus on Rule 1.4, communication. 1.4 also requires that the attorney keep the client informed about the matter. For example, providing updates as to the attorney's progress in carrying out the representation. The attorney must promptly inform the client of any decision or circumstances in which the client will need to make a decision. The lawyer must reasonably consult with the client about the means the attorney intends to use to achieve the client's objectives. The attorney must keep the client reasonably informed about the status of the matter and promptly comply with the client's reasonable requests for information. These obligations to keep the client informed are the ones most frequently violated, resulting in usually minor discipline for the attorney. Disciplinary cases often involve the attorney failing to inform the client about the progress, together with the attorney not being diligent and failing to carry forward the matter in a timely way. Rule 1.4a also explicitly requires the attorney to consult with the client about any relevant limitation on the lawyer's conduct. This refers to when the lawyer discovers or suspects that the client intends to engage in a crime or fraud. Rule 2.1 shortly and sweetly addresses the attorney's role as advisor. The rule requires that the lawyer exercise independent professional judgment and render candid advice. The comments explain that the client is entitled to straightforward advice expressing the lawyer's honest assessment. Sometimes the lawyer must tell the client that what he wants to do is illegal. Sometimes the lawyer must tell the client that his proposed course of action or theory of the case is so unusual or so tenuous that the client will almost certainly lose. The lawyer must not be deterred from giving the client this sort of straightforward and candid advice. Lawyers who get sucked into their client's criminal or fraudulent schemes have gotten there because they have been unable or unwilling to tell a paying client no. The comments to Rule 2.1 note that narrow technical legal information may not be useful to many clients. The lawyer may need not only to provide a legal opinion, but to outline all of the consequences, from likely outcome to expense to effects on other people. It is for this reason that the rules note, in rendering advice, a lawyer may refer not only to law, but to other considerations such as moral, economic, social, and political factors that may be relevant to the client's situation. The comments expand. Although the lawyer is not a moral advisor, morals and ethics impinge upon most legal questions and may decisively influence how the law will be applied. Lawyer, statesman, and Nobel Peace Prize winner Elihu Root is credited with saying, quote, "About half the practice of a decent lawyer consists of telling would-be clients that they are damned fools and should stop," close quote. This is good advice to recall when counseling clients who are intent upon pursuing highly questionable courses of action. This is the conclusion of the unit on attorney-client relations. Before our next class meeting, please also listen to the unit on withdrawing from representing the client, Rule 1.16.